Okay. So, like I said, I'm at Disability Rights Texas. And for those of you that don't know, Disability Rights Texas is the federally mandated protection and advocacy organization for people with disabilities in Texas. Our mission is to advocate and advance the legal rights of Texans with disabilities. We are a nonprofit organization, and as part of that, we provide free legal services to Texans with disabilities. And we take discrimination cases in employment, housing, and public accommodations. But we also have a healthcare team that works on issues around healthcare, special education team, an education team that does education issues, an institutional rights and civil liberties team, a foster care team that represents children with disabilities in the foster care systems. And then we also help with Social Security benefits and VR services, vocational rehabilitation services, if you're a client of TWC. So I deal with employment discrimination, voting, and public accommodations, but other attorneys at our organization do a lot of other issues to help people with disabilities. At the end of the presentation, I'll have some information about contacting Disability Rights Texas if you have perhaps issues in any of these other areas. You can also, of course, go to our website, which gives a more comprehensive and clear view of the types of services that we offer. In dealing with employment discrimination, the laws against disability discrimination in employment are the ADA, which is the Americans with Disabilities Act, but probably a lot of you have heard of it as the ADA. Section 504 of the Rehabilitation Act, which is a very similar law to the ADA, but applies to entities that receive any sort of federal funding. So that includes federal contractors that are employers, but also may include in the public accommodation context, like a daycare that receives federal funding for their daycare program, but would be traditionally probably thought of as an entity that has to comply with federal laws under Section 504. And also the Texas Labor Code, which is the state law, and also is very similar and has some overlap with the ADA. But all of these laws potentially could apply. And we'll talk first now about what employers are covered by the ADA. Most of this presentation is really going to be focusing on the ADA as the law that we're dealing with. And the ADA has certain types of employers that are covered. The first, of course, is federal government agencies have to comply with the ADA. Any private employer with more than 15 employees has to meet the qualifications of the ADA. And this is important because if it's less than 15 employees, they may not have any requirements to comply with the ADA. So if you're wondering whether your employer is covered or not, think about the number of employees it has. 15 or more has to comply with the ADA. State and local governments of any size, any federal contractors with federal grants greater than 10,000. And then finally, for the Section 504, employers that receive or give out federal assistance money. These laws make discrimination illegal in all employment practices. So this includes when you're applying for a job, when you're getting hired, going through the hiring process, asking for promotions or getting promoted, the pay that you receive, the treatment you receive while you're at the job, and then, of course, protection from firing and discrimination if you're being fired for discriminatory reasons. So essentially, these laws protect you in all aspects of employment. In order to be protected under the ADA, you have to be an individual with a disability. And we'll get to a little bit more about what a disability is in just a moment. But you're protected if you have an actual disability. Like I said, we'll look at the actual definition here in a second. Or if you have a record of a disability. So that may mean that you don't presently have the disability, but you did have it in the past. So you have a record of it. So this might include something like cancer, for example, that you presently don't have cancer, you might be in remission, but you're yet still protected because you have a record of having had a disability in the past. And then you also have to be qualified for the job. And what that means is that you have to be able to perform the job that you're talking about, that we're dealing with or without an accommodation. And we'll talk more about that. But so you have to be a person with an actual disability, a covered disability, or having record of it. And then you also have to be able to actually do the job itself. There's another piece is that if you're regarded as somebody having a disability, And so that actually should be point C here on this page. But this is somebody who is regarded as having a disability, but may not actually have a disability, but somehow their employer thinks they do. And so the employer can't discriminate against them based on this kind of belief that they're being treated like they have a disability. Now, I have a note here that even if you don't have a disability and you're just regarded as having a disability, that's not enough to get an accommodation. So you're protected from other types of discrimination if you're regarded as having a disability, but you are not entitled to an accommodation because in this case, you don't actually have the disability that you're being thought to have. And so you're not entitled to get an accommodation for this disability that doesn't actually exist or rise to the level of disability. So as I said, we were going to talk about what is a covered disability? What are these actual disabilities that I mentioned a moment ago? So you would know if you're covered as a person with disability, if you have a physical or mental impairment that substantially limits one or more major life activity. That's the third bullet on this PowerPoint. And this is these are the magic words of physical or mental impairment that substantially limits one or more major life activity. And the major life activities we are dealing with here are things like standing, walking, bending, reaching, sleeping, concentrating. Those are just a few of them, but those are the types of things that are considered major life activities. The law is much broader now. Because of a couple of Supreme Court cases, the law about what a disability had become very narrow. And it was very hard in the courts to prove that a person had a disability. But because of congressional action about 15 years ago, let's say, the law became clarified. And so these Supreme Court cases that had really narrowed the definition of disability were clarified through the ADA Amendments Act. And so now we know that the view of disability is much broader, and it covers a lot of conditions that those narrowing Supreme Court cases had prevented from being seen as disabilities. But now we know the law takes the view of disability very broadly, and a lot more things are considered disabilities than perhaps were considered more than 12 years ago, more or less. So some examples. Here are some examples of covered disabilities. And of course, this is not comprehensive. This is not everything. But here are some things that could be covered under the broader definition or definition actually listed in the law. That includes alcoholism, asthma, cancer, depression, diabetes, epilepsy, heart disease, migraine, headaches, orthopedic impairments, and complications from pregnancy. I mention here the complications from pregnancy because pregnancy itself usually is not going to be a covered disability. But if there are some complications to the pregnancy, something that makes the pregnancy potentially high risk, that would potentially be a covered disability under the ADA. So complications from pregnancy can be covered, but usually pregnancy by itself. And then also any impairment that affects bodily systems, such as neurological, digestive, immune, or endocrine system could be covered. So this is something that the major life activity is the bodily system. So anything that changes a bodily system, we know could potentially be a covered disability. Here, let's say, using the example of diabetes. Well, diabetes affects the endocrine system. And for that reason, among others, we would consider it a covered disability. So if you're kind of wondering like, well, does this fit? This doesn't affect my walking or this doesn't affect my bending. Think about, does it affect some other bodily system in a major way? Because that's how you could get the coverage of an impairment that affects bodily systems is considered a covered disability. The next slide deals with what about brief or intermittent disabilities? So these are things that kind of come and go. Are they considered disabilities? Is this covered under the law? And the answer is yes and no, which is, of course, a lot of the times the answer is yes or no when we're dealing with the law. But if it's a condition that is permanent, but only has temporary periods of actual disability. So something like this might be epilepsy, for example. So this is a permanent condition, but somebody only has a seizure perhaps twice a year. That is likely to qualify as a disability, yes. But if the illness is brief and the person is expected to recover fully, so like here, the example is a sprained ankle or the flu, it is likely not going to be covered under the law. Now, there has been some guidance. I'm sure people are wondering whether or not COVID would be considered a disability. And that there has been some guidance from the EEOC, which is the Equal Employment Opportunity Commission, that this idea of what's called long COVID, potentially is a disability. So that would be covered under the ADA as a disability, and then you'd be entitled to protections. There's also some case law around whether COVID itself, just on its own, would be considered a disability. But again, if it's brief and the person is expected to recover fully, then that's likely not going to be a covered disability. And I say here, but don't assume, because we don't know whether or not something is brief or not without kind of doing a deeper dig into what the disability is. So I mentioned very briefly about qualified, because remember, in order to be covered by the law, you have to be a person with a covered disability, which we just spoke about, and what that disability definition means. And then also you have to be qualified, because if you're not qualified, then you're not covered by the law. So qualified means that you're able to perform the essential functions of the job with or without a reasonable accommodation. So basically, can you do the job? Can you do the job without an accommodation? Or if not, can you do the job with an accommodation? And if you can, then you're qualified. So the key questions here are, one, what are the essential job functions? Usually an employment listing will list the essential job functions, or perhaps on the job, once you're working it, you can figure out pretty easily what the essential job functions are. And there sometimes is some dispute, about whether something is an essential function or not. And again, that's where it's not in the law. It's not clear always. It's not just yes or no. It's not black or white. And so that sometimes is where employers argue with employees about what's an essential function. But sometimes it is very clear. And you very much know what the essential functions are, and you can't do them, or you can do them. But this idea of what are the essential functions of the job is another question to ask. And if you can do them, is a reasonable accommodation needed to do them? And if so, did the employer go through the right process of engaging with you on their reasonable accommodations? Okay, so I talked a little bit in the previous slide about the essential functions. Here it does go into a little bit more detail about how the employer's judgment, so that what the employer says about what the essential functions are, often gets some deference, meaning that the courts might pay more attention to what the employer claims essential functions are. But really, at the end of the day, it's made on a case-by-case basis. Some ideas of helping to determine whether or not it's an essential function is, does that position exist to perform that particular function? Because if it does, that probably indicates more on the fact that that's an essential function of the job. Also, the number of employees available to perform that job function. If your job is the only job in the whole organization that performs that function, then that's more likely to be an essential function. If you work with 100 people and all 100 of you have to do that specific task, then we know, well, then that's probably easier to identify and put that specific task on somebody else. So it may not be an essential function of your particular job. And then, of course, the degree or expertise, the degree of expertise or skill needed to do that function. Is it something that others could do, or is it really specific to your job? And that's, again, how to decide whether or not something's an essential function for the purposes of whether or not you're qualified to do the job. The next one deals with hiring and interview process, and generally talks about what are your employer's obligations when you're getting hired, when you're going through the interview. There is a prohibition under the ADA that the employers are not allowed to ask you questions that are likely to reveal or find out if you have a disability before making the job offer. We'll talk, of course, a little bit about what happens after a job offer is made in a moment. But before a job offer is made, your employer cannot ask about questions that might reveal disability. So I have some examples of here of, well, do you have a disability that could interfere with your job or your ability to do this job? That's a pretty straightforward one. But another one that might be less obvious is, well, do you need an accommodation to perform this job? So they can't ask these types of questions until a job offer is made. So can't ask you questions about whether you take prescription drugs, whether you've ever filed for workers' comp or been injured on the job. Those are the types of things that would be prohibited. But they can ask you about the qualifications for your performance of the job. So if you have to drive in order to do a job, they can ask you whether you have a driver's license. That's fine. They can ask you, can you operate heavy machinery? If that's a thing that you would have to do for the job. The only kind of limitation on that is if it doesn't have to do with the job itself, then it may get into territory that makes it more murky and makes it probably less clear that they should be asking you. So if they ask you about operating heavy machinery and it's not a job where you're operating heavy machinery, they may be trying to get at whether you have a disability or not, when in fact, it has nothing to do with the job. So again, they can ask you about your qualifications. They can ask you about whether you can do the job itself or your performance of doing the job, but there are limitations on that because they have to relate to the essential functions of the job. So again, employers, of course, can ask whether you can do the essentials functions of the job. And the employers can ask about current illegal drug use. So past illegal drug use, and there's questions about how far past that can be. That may be a covered disability because of drug addiction being a covered disability under the ADA potentially. But if they're asking about current illegal drug use, that's okay. That's different than asking about past illegal drug use. And then the other time they can ask about things is if they need to ask for medical documentation, if you're requesting a reasonable accommodation. And we'll talk more about reasonable accommodations a little bit further into the presentation. So as I said, before a job offer is made, an employer can only ask so much. But after a job offer has been made, things change. Employers can start to ask more information. And they can ask questions of everyone so long as these questions are asked of everyone that has been hired for that position. So they can begin to ask a little bit more. They can also require a medical exam, but again, as long as it's required of all new hires. And then they can ask questions specifically about that medical information after they receive it. And that's, of course, only if it's medically related to the previous information. They can't just kind of make up new medical questions that they want if it's not related to what the questions were that they previously asked. So reasonable accommodations. This is probably the bulk of the presentation, maybe what people are most interested in, whether or not somebody's entitled to a reasonable accommodation, what a reasonable accommodation is. And we spend a lot of our time here at Disability Rights Texas helping people get accommodations in their workplace. As we've talked about, an employee with a disability, we've defined what disability is, and we've defined who's qualified under the job. An employee with a disability is protected if she can perform the essential functions of a job with or without a reasonable accommodation. Reasonable accommodations are changes, tweaks, assistance in the workplace that help a person do the essential functions of the job, help them apply for the job, or help with other parts of the job. And what that means is I have here examples that are closer parking, accessible training, things like that, that are not necessarily with actually doing the job itself, but help the employment in general, that help give that person equal access to the employment that they wouldn't have otherwise. And so again, things like closer parking, accessible training, an accessible bathroom, things that are part of the job, but are not actually part of the essential functions of the job. So reasonable accommodations are to help with the job, to help applying, and then to help with these other miscellaneous parts of the job. In order to get an accommodation, an employee doesn't have to use any magic words. That doesn't have to be in writing. Always a good idea to put this type of thing in writing, but it's not required. The accommodation request should disclose disability and the limitations that the disability has, and to actually, oftentimes, if you can, ask for the specific accommodation that you want. Sometimes we have clients that don't really know what they want and they just say, I need an accommodation. And that's okay, but it's always better to suggest a specific accommodation because you probably already know what that is, what you need. And you put that in the request. And so your employer knows exactly what you're needing and exactly what you're requesting. At that point, the employer and the employee should engage in what's called the interactive process. The interactive process is a back and forth between the employer and the employee about how to make this work, how to make this accommodation happen. If the accommodation that the employee asked for is not quite something the employer can do, well, then the employer should come back with another suggestion saying, okay, well, not that, but how about this? And so they should kind of go back and forth until they come up with an actual accommodation. And that's what's called the interactive process. Sometimes the first request of the employee is an accommodation that the employer just says, okay. And there's really not a lengthy or detailed interactive process because the employer just comes back and says, that works, let's do it. Here's how we're going to implement it. So that really just depends. But if not, then they have to kind of go back and forth. In terms of when an employer can ask, can be the one that actually affirmatively goes forward and asks the employer if they need an accommodation, is when there's an obvious disability. Otherwise, an employer should not be the one approaching the employee and saying, do you need an accommodation? If the disability is obvious, or if the employee has actually already told the employer about the disability, then they can approach them and ask if they need accommodation. But otherwise, that's not what the employer should be doing. So the key takeaways here is that an employee doesn't have to say, I need a reasonable accommodation. They don't have to use these magic words. They don't have to say the ADA or any kind of formal language. It's helpful if you want to do that, that's great, but it's not required. Doesn't have to be in writing, but again, it's great if it is. And then we know that using these words helps make things better. But if you feel like you've already made an accommodation request and it wasn't in writing and you didn't use the keywords, know that that's still a valid accommodation request. So then it begins. Then we have the interactive process, which I explained is about these good faith discussions. Of course, the employer shouldn't ignore the request. The employer should also just not say just no and then not follow up. Unfortunately, those things happen sometimes. And when that happens, that's when my organization, Disability Rights Texas, might get involved. And then I also always encourage employers that the person with a disability knows the most about what they need. And so listen to them and understand them and don't think that they're just trying to make, make things more difficult for the employer. The question about medical support is a good one because oftentimes after the accommodation is made for the request for accommodation, or there is some question by the person with the disability, well, I don't know if I want to request an accommodation because are they going to have to ask for my medical information? I don't want to disclose anything. And so the question is medical support required? Only if the employer asks for it, but the employer does have the right to receive some medical information. Some employers don't ask for medical support, but a lot of them do. So I think that that's something that unless it's a very obvious accommodation and a very obvious disability, it's likely that there will be a follow-up on medical information. And the employer doesn't have to pay for you to see your doctor or another doctor that you may need to see, unless the employer is insisting that you see a particular doctor. But typically this medical support comes from your own provider, the one that you've already been seeing for this condition. And in that case, you may need to make your own appointment and pay for your own appointment to get this medical support. A lot of my clients sometimes can just make their request through their doctor's kind of online portal. And so that might save you some time from having to make an appointment and also save money from having to see the doctor. It seems like that's pretty common for my clients right now. But they can ask for some support detailing kind of the accommodation that's needed, that you have a disability, and the limitations of your disability. They can't ask for a blanket medical release giving you all of your records. So there is limitation on what they can get, but they are entitled to confirmation of your disability, confirmation of the limitations of your disability, and confirmation of the need for that particular accommodation. So again, relatively brief what they need, but they need to get that from your employer that explains all of that information. Employers are obligated to treat this medical information confidentially, and it has to be kept in a separate file than your employee file. So it can't be kept in kind of your general HR file. And they can share that with your supervisors or managers who need to know about your reasonable accommodation. Any sort of first aid or safety personnel that would need to know if you required some emergency treatment or assistance at work. So if you had a seizure at work and this emergency management would need to know, it can be shared with them. And then also if there's ever any instance where the ADA compliance is being investigated or for workers' comp or insurance purposes, that may be shared if necessary. When does an employer not have to provide an accommodation? What kind of excuses, let's use that word, does an employer have that are valid excuses not to provide an accommodation? The first is undue hardship. So an undue hardship is anything that requires a lot of difficulty or expense. So if an accommodation you request is too expensive, then your employer doesn't have to do it. And again, there's often arguments about this, but sometimes it's easier to kind of know the answer than others. If you're asking for something, like you want a stool that's $29.99 on Amazon that is going to really help you because of your disability, it's going to be unlikely that your employer is going to say that that's too much money because it was $29.99 on Amazon and you work for a huge company that has lots of money. So that's probably not going to be an undue hardship. If you work for a very small company and your request is that they build you, a new office that is built privately outside of, the current building or the current office structure, okay, well then maybe we're getting more into undue hardship. So those are kind of two extreme examples, but we need to think about what an undue hardship might be and whether it is maybe too expensive. And it doesn't just refer to cost. That's one thing that's usually it refers to, but it also can refer to things that are just going to be too difficult to implement. And again, we think about, is it really too difficult to implement, or is your employer just being difficult themselves by saying they can't do it? Because sometimes we have employers who, just kind of lack the creativity or the motivation or the desire to want to do something, and they say it's too difficult, when in fact it really wouldn't be. So that's something to consider under undue hardship as well, is difficulty or also financial expense. The other requirement in which they can, and I'm using epilepsy here as an example in this slide, is a direct threat of when they wouldn't have to provide an accommodation is if this employee is a direct threat. So a person, for example, with epilepsy can only be excluded from the job if that person poses an actual direct threat. So the employer can't just think of, stereotypes or generalizations or general fears about somebody and say, okay, we have to exclude you because you're a direct threat. It has to actually be about that specific individual with that specific individual's medical history and disability. And it has to be something that can't be eliminated or reduced through reasonable accommodation. So if somebody is thought to be a direct threat, but a simple accommodation could reduce that or eliminate that threat, then we can't think of that person being employed as a direct threat anymore. So again, must be based on objective, factual evidence, including medical evidence and advancements in the treatment of whatever the disability is. In this example, we have epilepsy as the disability that we're using. In addition, direct threat, the employer also has to consider the duration of the threat. Is it once every 2 years that it might be a threat, or is it every day? Also, of course, the nature and severity of the potential harm from the threat, the likelihood that it will occur, and how imminent it is. And also, again, we want to ask, we need to know, could the threat be eliminated with a reasonable accommodation? Now, I mentioned at the very beginning that our website has some information that's probably going to be useful to you. So here's our employment discrimination handout. It is everything that my presentation just included and more. So I'll give everybody a moment to write down this website address, but our website has information not only about the other types of services that our organization provides, but also about handouts, so that it has information, additional resources about employment discrimination, has a lot of good COVID resources around the vaccine, what you need to know about your rights under the vaccine, about the vaccine and employment, about masks at work. And so there's a COVID section that you'll find probably some really helpful and relevant information about employment and COVID, and then also other issues around COVID if you're having other issues as well.
Leah, this is Edie. I just want to let you know I'm going to put the URL in the chat so that people can just click on it, and I'm actually going to put a shorter URL in the chat so that it's a little easier. So everybody, if you could go to the chat for that.
Very good. Yes, that's great. Okay. So I want to give a couple of links here. And the first one is something called the Job Accommodation Network. The Job Accommodation Network is a really good website that's very extensive, that gives you basically all the information you need to know about asking for a job accommodation. It gives you a sample letter you can use for your employer. It gives you accommodation ideas by disability, and it has a lot of different disabilities covered. It gives you basic information about the ADA, and it's just a really good, clear, comprehensive website. The other nice thing about askjan.org is it also has information for your employer. So they write things specifically for employers, and you can print it out, and it explains things to employers in a way that's very straightforward and clear. So I definitely recommend going to askjan.org about job accommodations. And then the EEOC also, and of course, in this example, I have epilepsy again, but if you go to the eeoc.gov/laws, that has good information just about the ADA generally. And then you can look more closely at the different types of disabilities. AskJan.org is more comprehensive in terms of the types of disabilities covered, but the EEOC has good information as well. And then here's our information. This is Disability Rights Texas. This is our intake phone number. And then our website address generally for how to apply for services. So this is if you want to do an intake at our organization, this is how to do it. I'll leave that up for just a moment, but then I'm going to close my slideshow and just make my video larger so I can look at the chats and answer some questions. I saw different chats come in while I was speaking, and so I want to make sure that if they're able to be answered, I'll answer them. But generally, this is the presentation. This is what I hope was helpful to you all and giving you some just basic information about your employment rights. I will, like I said, I'll go ahead and close the presentation. I hope everybody was able to get this information down, but I know it's also going to be shared in the chat. And then I'll also now look at the questions in the chat.
And actually, Leah, most of the questions you need to answer are in the Q&A.
Okay.
So you might want to go to the Q&A and look at the first one that came in is really under dismissed. And if you want to look at that. And I don't know if you feel like you can answer it or not.
Okay, yeah, absolutely. So I see that both the chat and the Q&A have questions.
I'll let you know anything that's in the chat, but I think most anything you need to answer is in the Q&A.
Okay, I see both. Thank you. Okay, so I'm going to look at this. Okay, I was seeing that some of them were answered, and Edie, I see that your answer is just that they're going to be answered. Okay, very good. So the first question we have is, can an organization require a driver's license as part of job description for a position that does not require driving? And that's a really good question, because that's an issue that we see, and probably not is the answer to that. So essentially, that is screening out people that may be qualified for the job and can do the job, yet they're screening them out by requiring a driver's license, even though the job doesn't require driving. So that's a really good question. My answer to that is probably not. I don't like when I see job applications that say you need to have your driver's license or list your driver's license number, yet there's no obvious way that this relates to the job itself. And so that's something that we are interested in. And I would say, if you see that and that's something that's impacting you, I would do an intake with us. And that sort of thing really makes me very frustrated, because it very clearly can screen out people with disabilities in a way that is completely needless. And again, like I said, I get very frustrated. I don't like when I see that sort of thing. So if that happens, I hope that you'll do an intake.
If you could go, Leah, click on the thing that says dismissed and look at that question.
Okay, when I do that, it says no dismissed questions.
Okay. I'll send it to you.
Okay, sure. Okay, so the next question is, do you have a list of available job coaches? The quick answer to that is no. But I would recommend working with TWC's VR, Vocational Rehabilitation, who can perhaps connect you with job coaches. If you go to TWC's website, if you're not already a client, you can apply for services there, and they can connect you with job coaches. We don't have that information, unfortunately. We're a legal services organization. And so typically we're not the ones hooking people up with accommodations, but that's a good question. So the next question is, what if an employer fires you after you disclose a disability? So just with that information of the question, that concerns me a lot, because that seems to be suggesting that you got fired because of the disability. I would need to know more about, what the specifics of this case are, whether to say, if there's not some reason or not. But yeah, just with that information, that does concern me. And so again, you could do an intake with our organization, or you can also file an EEOC complaint. An EEOC complaint is something that someone can do on their own. You don't have to be a lawyer to do it. You don't have to have a lawyer to draft it. You can file it on your own if you go to the EEOC's website. It has information on there about how to submit a complaint. And it's pretty straightforward. You fill out a form with your name, information, the employer's name, information, and then write a summary of what happened and why you think this is disability discrimination. Just because you disclose a disability doesn't mean your employer should fire you. So I'd want to know more about the situation to be able to see whether that's, a really strong case, or perhaps there's something else going on that makes it not as strong of a case. Okay. Okay, so I'm going to see over here. There's some other questions. Somebody has asked, what determines you to have a disability? And it sounds like this person might have a court in December to see if there's a court hearing in December to see if there's qualification for disability. I don't know enough about that question to know there are different definitions of disability depending on what the law you're dealing with is. So somebody under the VA may have a disability that is not qualified under the ADA, the Americans with Disabilities Act, or somebody who has a disability under the Social Security Administration may not have a VA disability, and vice versa. So all these different laws have different definitions of disability. And so just because you're qualified under one does not mean that you're automatically qualified under another law. So I talked in my presentation about what is qualified for disability under the ADA, whether you have a substantial impairment in a major life activity, and also whether you have some impairment that affects the bodily functions of your in your life, whether it be your immune system, your endocrine system, your neurological system, and that's what qualifies you generally under the ADA. But again, that's different than the definition under the Social Security Administration or the VA. Okay.
Leah, can you do me a favor? Go back to the Q&A and under answered, look for the one that starts with from somebody named FB.
Okay. I'm sorry. Give me one moment. I'm looking at the other that somebody did say that if you need a job coach for somebody who is deaf blind, there's an email in the chat that you can perhaps help find somebody, a job coach for somebody who's deaf blind. And then also another attorney at our organization, Danette, was kind enough to put a link to the EEOC, how to file an employment discrimination claim under the EEOC. Okay. Okay, so I see one more actually, Edie, that is quick, so I want to answer it. So it asks, should someone with diabetes always disclose that on an application? Generally, I would say no, that unless you need an accommodation, generally the idea is that you should not disclose disability until it's necessary. If you have diabetes and there's maybe an accommodation that you need, then yeah, you may want to disclose it. Or if you feel like there's a safety issue that would make you want to disclose it, you could. But generally, we recommend, unless there's a reason, not to disclose disability because of the risk that people discriminate. You know, if that risk wasn't there, then yes, of course, it would be something that you would share if you wanted and not share if you didn't. But because of this risk of discrimination, it does kind of generally seem like a better idea not to disclose disability unless necessary. Okay, so let me read this longer question. One moment. Okay. Okay, so this is a really good question. It's a really well-worded question. Essentially, this person is asking that they had a chronic health condition, sounds like it's probably covered as a disability, and needed an accommodation. Once they made that request for an accommodation, their employer changed the position to a classification for which this person wasn't qualified and reduced the salary by 10%. And the new job functions made the disability worse, and eventually they were terminated because of these changes in the employment. So the question is responding to an accommodation request by changing the job to a classification for which the requester isn't qualified consistent with the legal requirements? The answer is probably not. So I would need to know, of course, more about what's going on, but this does seem to me like the employer refused the accommodations that you were requesting. So you had some accommodations that were requested, and probably they were straightforward, or you thought that they would be something that could be implemented, but the employer here, rather than implementing the requested accommodations, said, no, we can't do that. Here's something else. So what was then provided was an accommodation that was not effective. Because like I said, the interactive process, the employer has to kind of go back and forth and they have to figure out something with the employee, but whatever is figured out with the employee has to be effective. It has to work. So it doesn't necessarily have to be the accommodation that the employee requests. It can be something else, but it has to work. We get into some disagreement sometimes with employers about what that means. And we also have to remind our clients sometimes that you don't always get the accommodation you want as long as the accommodation you're getting is one that works. So here it sounds like that the employer provided an accommodation that just didn't work because it was a position that made the disability worse. It was a position that didn't allow this person to do the essential functions of the job, and it resulted in termination. So this is an example of potentially an employment discrimination case One thing to consider, though, that I didn't mention in the presentation is the deadlines to file an EEOC complaint. Generally, you have up to 300 days in the state of Texas to file a complaint with the EEOC. So I'm not sure when this happened, but that's something to consider before filing a complaint with the EEOC. But if you filed the complaint within that timeline, this may be something that you'd be able to file on your own, or of course you could contact Disability Rights Texas Intake and hopefully go through the EEOC process. Okay, so let me see if there are any other. Yes, okay, here's another one. What's the best way to request accommodations if you need them even for an interview? Should you wait until you get an interview and then ask? That's a really good question. I think that waiting until you get an interview and then asking is probably the best. I mean, and that's assuming you need it for the interview and not for the application itself. You know, we have clients who need an accommodation just during the application process. You know, for example, maybe if there's an online application and there's a video component of the application that you have to watch and then fill out, and the video doesn't have captioning for somebody who is deaf, or we have issues with the website where you're trying to apply is not accessible to screen readers. So sometimes you need an accommodation for the application itself, but it sounds like that question was about the interview. I would ask once you get the interview to make sure that it doesn't impact a decision about whether or not to grant an interview to begin with. And then oftentimes, though not always, some employers are good about saying, if you need an accommodation, you can contact this person or this email. And then if not, you can reach out to the person who is giving you the interview and reached out to you to begin with. Usually the people who set up that sort of thing are in HR and should be, you know, again, this is a big assumption, but should be somewhat versed in this accommodation process. HR is typically the branch of a company, an organization that handles accommodation requests. Okay. Okay, so I see that there's a question. Okay, let's see. Oh, there's several questions. One moment, let me go back.
And there is one more question in the Q&A as well.
Yeah, I don't know what, under what tab?
Under open.
Okay, I already answered that one. What if an employer fires you after you disclose a disability?
You have answered that?
Yeah.
Okay, thank you.
Of course. Okay, so let's see. Okay, so this person is wondering, I guess it sounds like they need an accommodation for hearing loss and low vision, and that it took a long time for the accommodations to get implemented. And the question is this normal? So it sounds like it took 4 months for these accommodations. And then also, in addition, the process of getting these accommodations implemented meant going through a lot of different people, submitting information to HR and CCing the supervisor, waiting a month, nothing happening. And also a concern that too many people saw the medical records and health records during this process. Question, why didn't they direct me to the ADA coordinator to begin with? So this has a lot of pieces to it. I will say that HR is the typical entity that handles these types of requests. Sometimes ADA coordinators may be the one that handles it, but really I think oftentimes it's in HR. So that doesn't necessarily seem unusual to me or kind of have any red flags associated with it. The length of time that it took is also very frustrating. I don't know why it took that long. And frankly, it sounds like, you know, they waited a month before they did anything. And so that's very concerning. But sometimes we do see things take 4 months to get implemented. And I say that with regret, I say that with frustration, but I don't know that it necessarily rises to the level of a violation of the ADA. I will say though that sometimes when, in these 4 months, we see somebody during this time where they're having to wait, start getting job performance docs that they're getting performance improvement plan or disciplinary action. And then maybe sometimes while they're waiting for their accommodation, they end up getting fired because they can't do the job without the accommodation and they're not performing. So we understand the importance and the problem with having a wait. But sometimes if it takes a long time and it's a very frustrating process, but eventually it is implemented, that you may not have a claim at that point because eventually you do have the accommodation in place. And even though the process was very frustrating and inefficient, there may not be an ADA violation. But a good question about why it had to go through the HR. There's nothing in the ADA that states it has to go through an ADA coordinator. Most organizations or a lot of organizations don't have an ADA coordinator, and so it is very common for it to go to HR. But that's a good question, and that sounds very frustrating. And I'm sorry that you had to go through that. So are people who can't get the vaccine because of disability looked at as a direct threat? So here, I think this part has kind of two questions. The first is that, can't get the vaccine because of a disability. That is a somewhat narrow section of individuals who are not able to get the vaccine because of a disability. And typically there has to be really strong and good medical support of why they can't get the vaccine. And sometimes that medical support has to even be beyond their own doctor. It has to go through kind of experts on the vaccine to be able to state that, yes, this disability is one that means this person should not get the vaccine. So sometimes that medical support might be more than that person's doctor. And then whether that person is a direct threat. Well, here, there could be ways to mitigate, to lessen any threat around being unvaccinated. And so that might be having somebody be in a different area of the office, or maybe you have to always wear a mask or get frequent testing. And so I think that there are ways to lessen any sort of direct threat argument for not getting vaccinated. But on that, I will say the disabilities that prevent vaccination are relatively rare, and that those often have to be supported by not just perhaps one's own doctor, but other doctors as well. But it does seem like there are ways to lessen any direct threat pretty easily. The next one, I guess I don't know exactly what it means. It says, for WOTC purposes, should people click the I have a disability button? And unfortunately, I don't know what WOTC is. If you're able to put it in a chat, I can answer it. Maybe I see another message just came in. So work opportunity tax credit. So there are times where, and I don't know enough about that, but I will say that there are times where because somebody's a federal contractor, they have to ask questions about disability. And so it may be beneficial for entities to know whether or not somebody has a disability, or maybe it's good because they are looking to hire people with disabilities. So I think that there are times, and I don't know enough about this particular program, but there are times, especially with this. Yeah, so the employer, the next piece is the employer gets credit for employing different people, like veterans, people that use food stamps or disabilities. So this might be an example in which it makes sense to disclose disability if the employer is seeking to hire people with disabilities. Let me see that. There might have been a couple more questions.
There are a few more in the Q&A now.
Okay, I'm back to that. Okay, so the first one says that people don't feel safe disclosing mental health disorder to their employers. That's understandable, for fear of not getting hired, stereotyped, or fired. All understandable. And says, but what happens when they choose not to disclose and they have an episode at work resulting in termination? Does the employee have any rights at this point? Had he disclosed and had an episode? Do they have any protections under the ADA? So this is a really good question and is very complex in terms of the thinking of what to do and when to do it. But generally, if you have a disability that you think you're going to need an accommodation for, you need to have disclosed it first. And most of the time, if you do it after the fact, it's going to be too late. So this question and this example of they choose not to disclose and then have an episode at work resulting in termination. If the employer didn't know about the disability, then they are protected. The employer is. The employer, usually can't have discriminated against you if they didn't know that you were a person with a disability. And so had the person disclosed and had the episode, then they have more rights because they may have the right to an accommodation at work. And so in this example, I would think about whether or not the person could have accommodations in place that would have helped prevent having the episode at work. So an accommodation in place because of the disability might be, taking leave that, I need to have leave at work as an accommodation in place such that I can, not call it. I can call in one day if I feel like I'm having a specific issue that I'm going to be facing at work, or that if you're at work and there's a time that you need to leave work, that you have that accommodation in place to begin with. So that's an idea. That's one example. That's not necessarily what the accommodation might be. But I think that it makes sense to have requested an accommodation in advance that maybe could help prevent having that episode at work itself. And that would be an accommodation that you should be entitled to. But the question itself of what if I didn't tell my employer and then I have an episode at work, am I protected? The answer is probably not. The next question is there a time frame to provide accommodations? There isn't. So there's nothing written in the law that says, okay, if an accommodation isn't provided in 10 days, then they break the law. Or an accommodation isn't provided in 5 months, then they break the law. There's no deadline or rule. And you have to provide an accommodation, but in this example that we talked about earlier, that somebody was waiting around for 4 months to get their accommodation. If that were to be a complaint or if it were to go to court, we would look at what was happening in that 4 months. Was the employer doing anything? Or was the employer asking for the software to be delivered and that was going to take a month and that was the only place to get it? So kind of what was the process and why did it have to take this long? At a certain point though, and again, it's not clear, there's nothing in the law, but at a certain point, if the employer does not provide an accommodation, it's considered a failure to accommodate. It's considered a denial of the accommodation request. But it's not clear what that cutoff is, okay? But usually it's kind of when, a normal kind of perception would be, okay, this employer is not providing this accommodation. So at a certain point, when somebody, anybody would just kind of give up and think, okay, this person's never going to provide this accommodation, then that would be considered an outright denial, which is different than just taking a long time. So I've had accommodations that can take 10 months, even a year to get implemented because they are complex and it required doing a lot of different steps or ordering things or going through these motions. But during that full time, that full year that it was taking to get implemented, stuff was happening. It's still frustrating, but as long as the employer seems to be actively working on the accommodation request, it's probably not going to be considered a denial of the accommodation. I think that we're almost out of time, or we are out of time. And there are a couple other, links in the chats that people might want to refer to with good information, good resources. So I would encourage everybody to look at that sort of thing. Everybody has our intake line. You're welcome to do an intake with us if anything in this presentation kind of raised your thoughts about whether or not there was an ADA violation. I thank everybody for your time. I appreciate everybody's involvement and I hope it was helpful. So everybody have a good weekend and take care and thank you so much.